Good afternoon, everyone. My name is Noel Francisco. I'm a partner at Jones Day, and I'm proud to represent TikTok Incorporated and ByteDance Limited in this important First Amendment case. We thought that the argument went very well. The justices are extremely engaged. They fully understand the importance of this case, not only for the American citizens of this country, but for First Amendment law generally and the rights of everybody. We thought that they vigorously questioned both sides. They put us through our paces, but what really came through is that they understand the importance of this case. We're very hopeful of a favorable decision. I'd just like to emphasize a few points that came up during the argument. First, and perhaps most importantly, TikTok Incorporated is a United States company. It's incorporated in the state of California. It's got thousands of employees based here in the United States. The government does not dispute that it is a bona fide U.S. subsidiary operating in the United States in accordance with all of the applicable principles of American corporate law. Second, ByteDance Limited is a private company. It is a private holding company that is based in the Cayman Islands. It is not owned by China. No arm of the Chinese government has an ownership stake directly or indirectly in TikTok Incorporated or ByteDance. ByteDance, rather, is 58% owned by global institutional investors, including very large American institutional investors like Susquehanna and General Atlantic. It is 21% owned by its employees, many of whom are American employees here in the United States, and it is 21% owned by one of its founders, who is a Chinese national living in Singapore. Third, TikTok Incorporated exercises independent judgment with respect to the algorithm in the United States. The source code for the algorithm is brought into the United States and stored on servers located in Virginia. There, it's converted into executable code, it's modified, it's customized, it's trained, it's moderated pursuant to moderation policies, and it's implemented in the United States. So when TikTok Incorporated implements the recommendation in the United States, that is very much TikTok Incorporated's speech. That is the speech of a U.S. entity speaking in the United States. Fourth, the intellectual property for the algorithm is not owned by the Chinese government. It is owned by ByteDance Limited, which is a global entity, a company that is incorporated in the Cayman Islands and operates through subsidiaries throughout the world. And then my final substantive point is that the United States government concedes that it has no evidence that China has ever attempted to date to control the U.S. TikTok platform. It concedes that China has not attempted to censor content on the platform in the United States. It concedes that China has not attempted to misappropriate user data in the United States. And if China ever asked TikTok or asked TikTok through ByteDance to do any such thing, it would refuse. I think what we heard today in oral arguments, when all of the lawyers were up, were the important First Amendment principles at stake here. We're talking about a social media platform that is regularly used by 170 million Americans. That is half the country. This country has never taken the step of shutting down a speech platform, much less such an important speech platform, because, as the government effectively concedes in its briefs, it's afraid that the content that could come out on that platform might be, dangerous. We don't normally think of speech as dangerous. The Supreme Court has repeatedly said speech is not dangerous. And you don't shut down a speech platform because you're worried about speech being dangerous. That is the whole point of the First Amendment, that we engage ideas with ideas and we let the truth come out. That's the fundamental problem with this act. It doesn't reflect the trust that the First Amendment places in the American people. We are confident that the Supreme Court will place that trust in the American people, and we look forward to a favorable decision out of the court. I'd now like to introduce my colleague and dear friend, Jeff Fisher.
Thank you, Noel. My name is Jeff Fisher. I'm a lawyer, special counsel at O'Melveny & Myers, and I represented the creator petitioners in this case. So I'll start with where Mr. Francisco left off. This is an unprecedented case, and I don't think there's any way to think about it in any other fashion. The government has never threatened to shut down a speech platform in this country because of the ideas expressed on that platform. And so the point of the creators here and their participation in this lawsuit is to absolutely drive that point home and remind the justices and remind the public that this case is at core about Americans speaking to other Americans about everything from everyday life to current events to anything else they care to express themselves on this particular platform about. And that is a most cherished freedom in this country. Another way to think about this is creators expressing themselves in all sorts of ways, whether it be with words or art or music or anything in between, have a right to choose under our First Amendment what publisher is best for them, what editor is best for them. A journalist can publish in a particular magazine because they like the leadership and the owners of that magazine as opposed to someone else. A music band can post their music on a particular platform or play in a particular venue in a particular city because they find that that expresses their art the best. Any number of other permutations that you can imagine. We don't have any decision ever from the United States Supreme Court that has ever restricted the right of a creator, a speaker in this country to express themselves through collaboration with publishers and editors against their own wishes, that they can be overridden in that sense. And it doesn't matter whether we're talking about purely American collaborators or whether our American collaborators have also foreign corporate entities to which they are related as well. Whether it's the BBC, the CBC, or NPR, people can choose to express themselves on whatever platform they wish, free and clear of government interference, particularly when the government's arranged for interfering. And I think this is where we take heart from the hearing today. When the government's reason for interfering is we don't like the viewpoint or the content that's going to be expressed through that platform. That is the core First Amendment value that our framers enshrined in the very First Amendment in our Constitution to protect freedom of thought, freedom of expression, freedom to create, freedom to share, and freedom to learn from other people. That leaves the only other thing the government had to say in court today, which is that this act could somehow be sustained solely because of data security concerns that have been expressed in various ways in various legislator statements. We just don't think that's correct. And so one thing I'd like to emphasize is that whatever data TikTok has from users by way of that relationship, that creator-publisher relationship, is no different from the data that creators would give to Instagram, YouTube, any other platform to express themselves on. There's no difference between the data in one place versus the other. And also, the data that's shared is done so on a voluntary basis. So one of the justices today expressed the concern about paternalism that comes from the government in this case, whether it be to protect us from ideas or to protect us from choices we might make to best express ourselves and share data about ourselves with our publisher. We think that's our choice to make. It's not the government's decision or its right to make that choice for us.